Okay, it's recording now.
Huh?
Recording now.
Okay. Hey everyone, it's Roxanne Grinage and Faruq Robinson. It is April 5th. It's a Saturday, 2014. I got the date right this time. Okay. And we're not having a trial prep workshop. What we're doing is we're demonstrating an administrative solution series that I stumbled upon in my first federal case. When I saw the corruption in the U.S. Eastern District Court as far as the federal court was concerned, I saw the docket closing. I used my last filing in the docket to provide every single filing an active link to it so that you could see what would become censored later. You could actually analyze it later, and if you post it to a U.S. citizens controlled public docket, it never goes away. Why do we want to take our docket analysis and put it somewhere where it never goes away using the posting abilities of the internet technologies instead of running around looking for sponsorship-driven dollars to take up our story? Because it's an intricate analysis of a scorecard. It actually, the docket of any particular venues, municipal court, trial division court on the state level, family court on the state level, they control what you can see and what you can't see. It's piecemeal, and we learn to get into the federal court as soon as possible because it is a public record, especially now with e-filing capability. It immediately becomes public record, and we can use our responsible energies to go, our community development energies and our sharing our information, not only to help others, but so it's there when criminal justice professionals come, when funding source decision makers come whose agenda hasn't even aligned yet with that jurisdiction. But as more and more are noticed, the people making the decisions about reform and public safety that are authorized to do something about it, our record of our docket analysis will be there. What is the name of our solution series? Docket Never Lies. Individual accountability can be measured through docket analysis. Instead of talking about the corrupt government, an amorphous thing, instead of talking about systems and processes, and I got messed up by the system, these are people, individuals, acting in serial criminal fashion, doing the same thing over and over and over again, committing felonies in accordance with what the U.S. Department of Justice Attorney General says is official corruption, fraud, and civil rights violations. So just because they're officially in a position to commit felonies against you, it does not make the severity, loss of theft and fraud and personal injury any less. So we want to use our docket analysis. We want to actually go through this exercise. You hear me talk all the time about we are more alike than we are different. Standard access, momentum, community. This is the case. In this particular case, not for Robinson's case, but there's a step you have to go to zoom in on those case merits, case challenges, right? We don't all have the same claims, but when you zoom out again, now you have individual accountability. Once you've posted in rows, columns, and tables, you see the same names showing up again. You see people coming out of the district attorney's office that are super lawyers, that's all they do is get convictions for false allegations of child abuse, and then you find out that they're sitting on the board of directors for the Department of Health and Human Services contractor. So that's why we want to speak in a voice of constituency, but each voice knows more about its case than anybody else does, right? And has literally analyzed its docket and can tell you exactly when it became perverted, who committed fraud upon the court. And that's what we're going to do here by interviewing Faruq Robinson, who nobody is more qualified than to talk about what's true and not true that has been affected as the court speaks its own language. These dockets have their own language that We're not taught how to speak, but we have to learn how to communicate with the courts in different venues with the instruments that they use. So first, I want to point out something that Faruq did. The challenge for a person suffering criminal charges for false allegations, particularly false allegations of child sexual abuse, is to be able to stay alive in the docket with obstructive court-appointed counsel. No one in their right mind wants to be in a venue where the language is a foreign language and the gears of, in this case, Pennsylvania Code Title 234, Rules of Criminal Procedure Governing Pretrial Discovery, are clicking off and they have no attorney expertise whatsoever. So yes, you want attorney representation, but us being people with common sense, we recognize immediately that our claims, our merits of our case and our innocence are not being represented. That the court-appointed counsel is actually working with the prosecutor, the local district attorney's office, and allowing the local district attorney's office to send someone in there, in this case, a very wealthy, powerful super lawyer from whose claim to fame is achieving the most convictions for sexual child abuse. B.B. Holtzman Kivitz was allowed by Gary Sanford Server, the court-appointed defense counsel, to be entered into the docket as his, Faruq Robinson's, privately retained defense counsel to enter a motion for reconsideration on behalf of, and she was allowed to, the trial division docket. This is where you have to recognize that the trial division itself, the court, actually has RICO liability, racketeering, influence, corrupt organization liability, in allowing her to be listed as a privately retained defense counsel, while on one of the 5 consolidated public police incident reports, and entering on behalf of the adverse party, City of Philadelphia DHS Children's Alliance, that used the false allegations of sexual abuse to pluck the children, to kidnap them for profit and severely injure them having been separation trauma injured, parent alienation injured, and not having proper supervision and care for over 2 years now.
2 years.
Yep. So that's in the trial prep session. You'll see the different things that the person making the false allegations, the mother-in-law, how she's financially incented, how she had asked Faruq to use the children for tax purposes, exemptions on 2 of the children, and when he said no, she began to make all these false allegations. You'll see how she defamed him in the community, abused her church relationships and so on, and how the children were allowed to be up on the phone at 1 o'clock in the morning. Mm-hmm. So by them removing the protector parent, they violate, of course, our constitutional rights to give our children our own police and principles and systems of police, and our children don't know who they are, so they can only be perpetual victims. And they pay and have us pay the people that are literally abusing and neglecting our children. So Faruq Robinson took HireLyrics advice, right, and filed on his own behalf. He didn't file a notice to terminate the attorney. He filed to the administrative court judges on February 20th, right, of the trial division. He addressed it to the administrative judges, the ones who are responsible for the functioning of the court of record, right, that there has to be a reliable record. And he pointed out all the legal malpractice that was occurring of Pennsylvania Code 234, Title 234, rules of criminal procedure pertaining to discovery, how the district attorney was able in the docket to say, I suggest that we just waive witnesses, and how his court-appointed attorney, Gary Sanford Server, just went ahead and said, okay, no problem, yeah, cool. It's like, okay, that's all right with me, you know? And so where he is actually being fast-tracked without discovery, without witnesses, without subpoena of records, without anything, and not even able to face his accuser. He's not even able to cross-examine his accuser on the stand, you know, the person who started the false allegations, because the assistant district attorney's office was more than happy to pick it up to aid and abet the cash cow billing machine of City of Philadelphia DHS Kidnap For Profit. It all works hand in hand. Then we open a DPW welfare fraud case. Then we out of Harrisburg. But if you notice, that's being handled by a City of Philadelphia DHS legal department lawyer as well. So I just want to point to, so the first thing we did when we pointed out to them and that in the letterhead that he had a witness, that he had retained a legal administrative assistant who is now a witness to the not a witness to his claims, but a witness to the records, to the materials, to affidavit testimony, to forensics evidence, to all the paperwork that he provided, the case history. I'm now a witness, and I can be an expert witness according to the federal rules of procedure 8036. Anything that you have as a result of your regularly conducted business activities, your records that you regularly gather, you can talk about it. And that's how law clerks now, paralegals, and legal assistants can give expert witness reports. As long as we talk about what is in the file, what's missing from the file, and what changed in the file. And I gotta tell you, this appearance of B.B. Kivitz Holtzman and my call to her that morning when I noticed that she had appeared as a privately retained counsel and that her motion for reconsideration had an asterisk, I assumed it was an asterisk because it was about one of his minor children, right? But I talked to her live, she answered her own phone, and she said, no, I'm attorney for Children's Alliance, right? And if you want a copy of that motion for reconsideration, you'll have to get that from your attorney. I said, well, that's one of our issues. He's not giving us any. But besides that, are you aware that you are appearing as privately retained defense counsel for Faruq Iman? She said, that can't be. I am attorney for Children's Alliance. But it didn't change in the docket until after they continued the motion on hearing. And the motion on hearing was granted, and her motion stated simply, the reason why we shouldn't have to give transcripts and notes of testimony is because Children's Alliance decided it was just too much work to do and stopped doing it. All right? That's what the motion said. So as a rule, we just don't even bother keeping records anymore. All right? We just take kids. Right? Okay, so I want to demonstrate for you with Faruq's case the docket analysis. And it's ideal to have someone that you can interview for the docket analysis, as opposed to just me looking over it and saying, okay, what does that mean? They said, you'll see in here, there's one point where they say that because the defendant rejected the deal, right, that was offered, it's now under seal. So someone even looking at the docket has no idea what the deal was until you talk to the affected party, right? So that's one of the questions I'm going to be asking. Oh, do I have a pen? Do you have a pen? Okay. Oh, thanks. Okay. Now let's go through the most recent docket. I have the Form 990 that nonprofits have to file their taxes for 2013 and 2012. B.B. Holtzman Kivitz is not only super lawyer getting the most convictions on child abuse out of the district attorney's office for Children's, she's on the board of directors of Children's Alliance, which is a fiduciary beneficiary. She makes money from what Children's Alliance makes, okay? And their taxes, they earned $2.5 million more than $2.5 million in 2013 and 2012. Did you see those? Fruit?
Yeah.
Okay. Yeah. So let me just hold them up so people know we have them. Okay. Hold on. Here is where she shows up in the court calendar. This is the first thing when a legal secretary or anybody's checking a court calendar to see where their person is supposed to be, their lawyer, maybe they're working for a lawyer or their client that hired them. Here I see Gary Sanford's server. This is where she started showing up in one docket, the 4843 docket, right? The 4473 docket. Now that's the docket, the police incident report that all 5 are consolidated under. She literally took control of the record as his privately retained attorney. Let me see if I have Here's citizensaudit.org. They say nonprofit 990 search. And here they have their taxes. Taxes, by the way, are a matter of public record, okay? So they have the 2013, 2012, 2011, and 2010. I printed the 2013 and the 2010. Philadelphia Children's Alliance. Here's where they break down everything, their salaries. The person, the director of the nonprofit, lives up in Huntington Park, and she gave herself $90,000 last year for her salary. For what? For not even bothering to type up notes about children's welfare, child welfare? Or we just decided it was too much work, so we're not going to bother. And actually put that, that's how flagrant the perversion of our court of records are, that an attorney, just because they're well positioned, is allowed to do that. Here they go. Now, just so you guys know, see how thick that is? That's what your taxpayer dollars are paying for. For them to talk about how much money they're making off of your children to the federal government. Okay? Now this is 2012. They made contributions and grants. Here's their income. $2,954,298. The director is Christina M. Kirshner, executive director. And the preparer's signature is David G. Fall of Wayne, PA. There's their employer identification number. These things are important when you start suing people for their assets. See, when we come personal injury and RICO in the federal case, our damages are also are added to our costs. We have damages for what they took from us. We have costs for what it took to prove it, right? And then we're asking for criminal referrals, where we get what the Kids for Cash prosecutors got was attachment of everything. On September 9th, when on September 10th, 2009, when I was following up at the federal clerk's office my first federal complaint against family court, the legal intelligentsia had a headline on it at the clerk's desk that said that convicted judges in the Kids for Cash had pled a deal. They said that we're willing to do 10 months each in a federal prison, but let us keep the $6.2 and $6.8 million in kickbacks. But our esteemed bipartisan prosecutors, Mike Vereb and David Pasquale, who's now Pennsylvania Auditor General, right, and Kurt Schroeder, Honorable Kurt Schroeder, They said, oh no, you're going to each do some time, and we're going to attach your boat, your car, your house, and everything else you got. You're going to pay the money back. So that's why it's important to have these identifying numbers, because it is financially driven. Recognize the industry drive in this, right? If you can remove, I know this seems really harsh, but if you can remove your personality long enough to, to say, instead of like getting caught up in how could they do this and how does it, if you could look at it like a scorecard, you could actually look at it with no personality. It's being laid out for you. Why they're doing it, you have all the components of a crime. Motive, the reason, opportunity, and modus operandi, the way they're doing it. And they do it over and over and over again. That's serial crime. All right, so RICO. Okay, now. And they gave themselves a little golf outing. They gave themselves a $50,000 golf outing and something called the Bear event or something. I don't know if they went to Bear Mountain or whatever they did, but that was another $50,000. Yeah, exactly. Yeah, it's like they're just partying on our children. But they can't type up a status report about what's going on with our children, because they don't never meet our children. The guardian ad litems never meet our children. They don't care. All right, now let's go over this. Is this the one I want to ask you about? 326, 329. Okay. Okay. Let's start right here. This is a criminal docket. By 329, B.B. Kivitz Holtzman is off of there. All right? You think she'd be off of there if we weren't publishing, aggressively marketing that we knew she was on there? No, she'd still be on there. And also when I did a calendar search for every time Gary Sanford Server is supposed to be in court, it's all year long, every day, all day long for everybody else, right? They schedule according to the attorney's availability, right? So he just stays in court. She was only in court for those 3 days. His motion hearing, his pretrial hearing, and his trial. They brought in the big guns, the executioner, if you will, to make sure a wrongful conviction happened without due process of law. Okay? So there's a lot of remedies for that and a lot of options about asking for a speedy trial. Like you got, in other words, after we do docket analysis, we report, just like we reported the legal malpractice of the criminal rules of procedure, we can report all the anomalies in this docket, right? We can report where it was the court's fault, why this has been delayed. Mm-hmm. This is what we're going to file is a notice of mistrial. Mm-hmm. We're telling you right now, when we go over this docket and we're telling you everything, the concise errors in this docket, there's a mistrial right now. Mm-hmm. You know, so you either start giving me a speedy trial with discovery and due process and witnesses and subpoena of records. And in Pennsylvania, I think that's 120 days. You take responsibility for that. But if you go to court, if you go to trial on this on 4/21 like you plan to, it's a mistrial, and I reserve my right to immediately appeal. And here's your notice of RICO liability. You are now a racketeering, influence, corrupt organization. You have individuals working in here racketeering. The definition of racketeering is profiting off of illegal conducts, right? And the court is aiding and abetting it, is the form that's allowing it. All right, so this is your docket?
Yes.
Okay. Your judge is Charles J. Cunningham III. Okay. Event type. Formal arraignment. 5/2/2003. Did that occur?
Yes.
Pre-trial conference. 5/28/2013. 9 a.m. Did that occur?
Yes.
Was it before Honorable Judge Donna Wolper?
Because I was actually in jail 5 to,
I got out Cinco de Mayo, May 5th.
So you were
So
not
that-
present at
yes.
the form. So that's an anomaly. Okay, you can't be arraigned. Were you ever brought before a monitor, a video camera, or anything to plead?
No.
An arraignment is where somebody has an opportunity to plead. They read the charges and they say, "How do you plead?" So here's the first, as early as May 28th, 2013, is the first lie in the docket, in the record of the court, right? He could not have been arraigned because he was incarcerated. And he was never asked. An arraignment means he never had a chance to plead. All right? Still incarcerated, not pled. So here, this brings up a big red flag about Judge Donna Walton. Why would she enter this into the docket? All right? Now, pretrial conference, pretrial bringback. What is a pretrial bringback, Faruq?
I have no idea.
Yep, we need that defined. They're just like throwing all kind of weird words in there. Pretrial bringback. This is why I wanted to interview Faruq, because I see some things in here that I've never seen before. It's like they say things, and it's just, it has nothing to do with law and practice of due process. A pretrial bringback. All right, so were you brought in 6/18/2013?
I gotta look at my subpoenas.
Confirm with subpoena. Okay. What is the define this? Pretrial bringback. That if you can't be brought back if you weren't brought in the first time. Not arraigned. You know, failing to receive an arraignment in the period of time, I think it's 3 days of incarceration, is grounds for a lawsuit as well. Like a state lawsuit, like for every day you're incarcerated, you could charge $100,000, you know, without being arraigned. All right, scheduling conference, 7/3/2013, with Judge Charles J. Cunningham. Did he show up on July 3rd, 2013?
Yes, I remember that.
Okay. Status, 8/8/2013, with Judge Charles J. Cunningham.
Yes, I remember that.
What, at the status conference, had Gary Sanford Server been assigned to you yet?
Yes.
Is that when he got assigned to you at the status conference?
No, he was assigned to me before I went to this one.
Yeah, there's a false statement in this docket where it says that the defendant failed to get counsel and they rescheduled, when actually an attorney came into his prison cell, got him to sign power of attorney, and took $2,000 out, $2,200 out of his account, and didn't show up. So the court doesn't recognize that you were just another victim of the same predators working inside the court, the racketeers. What it is bandito style. They say, well, you don't have an attorney. You don't have an attorney, so we're going to penalize you for that. Status, 8/9. Did that happen? That's another status conference?
Was that the next day?
Yep.
Because you said 8/8 and then 8/9.
Yeah. Did you have two status
I
conferences?
don't remember them being back to back like that.
Okay.
Yeah.
Don't think so.
Yeah, this is